All right, welcome to today's verdict. I'm your host and trial attorney, David Lesh. We have a big show today, starting out with children who were not given the services that they were supposed to be given by the Board of Education in the city of New York, and ways we're trying to reinvent what the Board of Education should do if they were given an order as to particular children and what their services should be. Next up, we're going to talk about freelancers and who are not paid by a particular company and how that company has now settled with the city of New York. Beware. Treat those independent contractors well, or there's going to be a lawsuit. And lastly, we're going to talk about homelessness in New York City. We have a council member on here, Council Member Diana Ayala. She's going to be talking a little bit about bills that is coming out of the council that unfortunately have been vetoed by our mayor. Well, as you can see, we have much to get to, so stay tuned. Today's verdict starts right now. All right, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We're here with Council Member Diana Ayala, the Deputy Speaker. How are you doing today, Diana?
I'm doing well. Thank you so much for having me. I'm really excited to be here today.
I know you've been pretty busy over the summer, so many things going on, a lot of events. Part of the job, I guess.
It is, but it's an exciting part of the job. You get to see a lot of folks that we haven't seen all winter long and just enjoy each other's company.
It's nice. I like it. Okay, let's get into homelessness. We talk a little bit about it in New York. I'm a native New Yorker. I've been living in Manhattan for about 35 years, born and raised in Queens. So I know what it's like to be here. We have a homelessness problem. Okay. What are your thoughts?
I mean, you're right. And I was formerly homeless as well. You know, I mean, this is not something that's new to me. So it's ironic that I ended up, chairing the Committee on General Welfare, but I think that life experience has been really helpful. Look, I think that we've, New York City started to see an increase in the number of homeless, unhoused families and singles during the Bloomberg-Giuliani era, right? There were a lot of policy changes that were made because there were a lot of thoughts over folks making themselves purposely homeless in order to qualify for certain subsidies, right? Which to me is ridiculous.
That's ludicrous. That's crazy. Okay.
It is, and it doesn't recognize that we have a pretty significant percentage of New Yorkers that are living below the poverty line that actually do need a subsidy, right? If you're a person with a disability and your income is not going to change, you may need a subsidy. If you're an older adult that retired, I mean, most of my seniors in my district are making maybe $12,000 on retirement. That's not enough to make rent these days. We all know that, right? Working minimum wage is not enough to pay rent. And so what we've been seeing is that as a result is an increase of the population in shelter. So we're now upwards of 40,000 New Yorkers, not counting asylum seekers, New Yorkers that have been in shelter for maybe 3 years at this point. The time it gets longer and longer. Before you would be in and out, maybe 8 months, you would find an apartment, you move out for a bunch of different circumstances, reasons. Now people are just not able to move out of shelter as quickly as they used to. And now you add the additional issue of asylum seekers coming into the city that are competing for the same, level, the same beds, right? The same space. And we're running out of space. And so it occurred to us that we should probably start looking at, a proactive way of addressing what we do have control over. And that's our own homeless census count, right? The 40,000 plus people that have been stuck, warehoused in shelter for years. How do we get those folks out? Well, one, we prevent them from coming in by expanding the eligibility criteria for the city FHEPS voucher, because right now, what the voucher does is that in order for you to qualify for the voucher, you have to be in shelter, which we know is you have to pay the city's paying 2 and 3 times the rate of rent just to house that family. Why not keep them in their apartment so that way we avoid the added burden of the cost, plus the added burden of having to look for an apartment because that family already has an apartment. So Then we look at what we're doing inside of the shelter. And so we changed what's called the 90-day rule. So the 90-day rule is a stupid rule that existed, I think it was a Giuliani era rule that required you to be in shelter for 90 days before you could even apply for any subsidy program or services in the shelter, which is ridiculous. We should be starting that conversation on day one, right? Because we want to move families out as quickly as possible. And we thought that these were common sense, policy decisions. Unfortunately, the mayor doesn't agree. And unfortunately, there's still a lot of that rhetoric, right? That people will stop, purposely stop paying rent in order to qualify.
Why do you believe the mayor doesn't agree?
Well, because again, I think that he, very much like, Bloomberg and Giuliani believe that people are going to stop paying rent on purpose just so that they can qualify. But there are a lot of, in order to qualify for a city FHEPS voucher, not everybody qualifies, right? You have to, you have to have a certain income. There's a host of requirements that not everybody's going to meet. So it's kind of ludicrous to assume that people will just stop paying rent, to receive the subsidy. There's also the disagreement about what the cost of the voucher expansion would mean. The city is estimating 17 billion. We haven't seen any evidence that suggests that that's even a factual number. We actually believe that, this will be a cost savings to the city because it would prevent us from having to pay 2 and 3 times the rate of regular rent, to house a family in shelter. And so, we'll see. The mayor veto, we overruled the veto at the city council, and now, we will wait to see if the administration decides to sue.
Well, that was my next question. Where do you think we're heading here? I mean, are we heading into court? What are your thoughts?
I mean, I think that they're strongly considering their options.
Does the mayor, though, have any leverage? Because it does seem that many New Yorkers think that services are being taken advantage of by certain groups, right? What can we do to convince Mayor Adams that that's not the case? Do we do that through the media? Do you do that grassroots? How do you make him understand? What's your position on that?
I don't think that there is a way to make him understand. I think, the mayor hasn't been very good at engaging with the body. I think and for me as the chair of the general welfare, I don't necessarily it didn't have to be these bills, right? But give me something, right? There has to be a plan of action. We can't just be holding press conferences and complaining about the influx of asylum seekers and the responsibility of trying to find a bed every night and how impossible that's becoming, and then not have a proactive plan for reducing the census count where we can. We have a lot of services that are already paid for, that we've been funding for years, that can help move families along. There's a lot that we can be doing internally. So I've always said to the administration, I'm like, if you don't like this plan, then what's your plan, right? What is the alternative? Give me something. And we haven't seen that.
Do you have any tips for somebody who's watching today who may be homeless or has a family member who's homeless?
Yeah, if you're an individual that is facing eviction, please speak to Homebase. We have a lot of programs and services to try to keep you in your apartment. There are ways to pay retroactive rents. There are ways to, we have legal services to help speak with, your landlord. There are ways to prevent, eviction. And for those of you that are facing eviction, I just want you to know that we're fighting like hell at the city council to ensure that we get you out of there and into a home of your own as quickly as possible.
Well, Councilmember Ayala, I'd like to thank you very much for being on the show. First time being here, and we hope to have you back so you can discuss a little bit else what's been going on in your district, okay?
Absolutely. I look forward to that.
In the meantime, have a great rest of your summer. All right, stay with us. Today's Verdict has so much more coming up right after this. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have with us Emily Hoffman, an attorney with the Department of Consumer and Worker Protections, an organization that we have featured on today's verdict many times in the past. Emily, thanks for being here today.
Thank you for having me.
Why don't you give a little bit of a background story to the Department of Consumer and Worker Protection so we can reacquaint our audience with the wonderful work that you do?
The Department of Consumer and Worker Protection used to be known as the Department of Consumer Affairs. So we're the agency that's tasked with essentially improving the economic lives of New Yorkers, whether that be by ensuring their rights as consumers or as workers. So specifically, I work in the Office of Labor Policy and Standards, and we are the division of the agency that is tasked with protecting workers. So we enforce essentially all of the city's workplace protection laws. So that includes the Freelance Isn't Free Act, which we're here to talk about today. It includes the Fair Workweek law, which provides fair scheduling, predictable scheduling for fast food and retail workers. We enforce just cause protections for fast food workers, the paid safe and sick leave law, and protections for delivery workers, among other things. So that all keeps us pretty busy.
It sounds like it. So let's talk about the reason we're here today, if we could, and the particular acts that were probably violated.
We're here today because the city recently settled a case against a magazine called L'Officiel, and the case had to do with violations of the Freelance Isn't Free Act. So this is a law that went into effect in 2017, and unlike some of our other laws, which offer protections for employees, this law is specifically geared toward people who have not been classified as employees, people who are classified as freelancers or independent contractors. So that basically means someone who was hired as an independent contractor to perform services for compensation for a hiring party. The law provides protections, including the right to a written contract, if the agreement is worth a certain amount of money, the right to timely payment, which means that a worker has to get paid by the date agreed upon in the contract, or if there is no date, they have to be paid within 30 days. And then there are also protections from retaliation.
How did you come aware that this magazine was violating this particular Freedom Isn't Free Act?
We started receiving complaints a couple of years ago, and we just received more and more. We operate something called a court navigation program. We have 2 staff members whose titles are court navigator, and their job is to process complaints that we receive under this law. So we started receiving more and more complaints against L'Officiel magazine. We got in touch with the National Writers Union, who was also aware of a lot of people having issues with this magazine just not being paid.
What in particular seemed to be the major complaint here?
The main complaint was not getting paid. Workers were not getting paid, or maybe they were paid very late, or they were paid partially, but not what they were actually owed. And it was impossible for them.
This is a French company, if I remember correctly. Am I correct?
I think it does have some French connections. I believe the ownership is currently based in Hong Kong, okay. But it does have global properties.
So do those global companies have to comply with the failure to pay, or should I say the freelancers on time, the Freelance Isn't Free Act, even though they're not necessarily based in New York? I mean, do they still have to follow the regulations spelled out in the act?
Our position is that the law applies if the work has a connection to New York. So okay. If workers were based in New York, doing work in New York, or if the company, had ties to New York, then they were covered.
All right. So you found out that the magazine's basically not paying the gig workers and the freelancers, the independent contractors, and not paying them within the 30, whatever the contract says, or at least within 30 days. What's your next step? What do you do?
our next step, we gathered a bunch of these stories, and we talked to the New York City Law Department, which, you know, is the lawyer for the city and also the lawyer for all of the city's agencies. So they basically became our lawyer in this case. They met with the workers who had come to us, investigated the complaints, and filed a lawsuit. And the lawsuit specifically alleged that L'Officiel had committed a pattern and practice of violations of the Freelance Isn't Free Act. So our law actually has a provision that if the city finds that a company was engaged in a pattern and practice of violations, then the law department can file a lawsuit against them.
And where did they file? State court, federal court, someplace else?
It was in state court in New York.
Okay. So, and when was it filed? When was this?
It was filed in late 2021.
All right. So then walk us through what resulted it as a result of the filing. What took place?
The company was pretty willing to settle, is my understanding. Ownership has also changed since the time that a lot of these violations occurred. So they, I think, understood that their practices had not been up to the law's standards, and they worked with the city to achieve a settlement. And so that's what officially happened a couple of weeks ago. So the case.
I was going to say, let's talk money. How much did they settle for?
So the sort of top line number here is about $275,000, and that money is what we call double damages for the 40 or so workers who we and L'Officiel were able to identify as being owed money. So everyone's getting essentially double what they're owed. But because we want to make sure that everyone whose rights might have been violated gets what they're owed, we agreed on a complaint process, or a claims process, I should say, that is going to be open for 6 months. So if anyone who we didn't catch in the settlement negotiations who believes that they are owed money under the law can file a claim. They have to produce some documentation of what they did. They submit it to L'Officiel. L'Officiel evaluates it, and then those workers can also get compensated under the settlement. And if there are folks who might be unsure of whether they are covered, we're encouraging them to come to us, and we can kind of help them navigate the claims process.
It certainly sends a message throughout New York City that you have to treat these independent workers fairly. And listen, they're the ones who need the money more than anybody else, because they're not even full-time employees many times, freelance workers. So what are your thoughts in terms of the future? Do you think that maybe companies will take a look at the settlement and abide by the law, or what do you think?
That is our hope. That's why we want to make sure as many people as possible are aware of this settlement, both in case they're covered and are able to get money. We want those people to know about the settlement, but also, we do want, as you said, we want to send a message that we are going to be enforcing this law. And if hiring parties are violating it, we are going to be looking into that. So, we hope that hiring parties and companies take notice and get their operations in order. But, we are always paying attention to the complaints that are coming into us and to what we're hearing from the freelancer community.
All right, Emily, I want to thank you very much. Emily Hoffman, hopefully you'll come back and join us. It's nice to have actually seeing you for the first time. Say hello, give our regards to the rest of the people in the office, and we'll see you soon.
Thanks so much. Take care.
It's our pleasure. All right, stay with us. Today's Verdict has so much more right after this. Okay, welcome back to Today's Verdict. I'm your host, David Lesh. We have returning with us Rebecca Shore, who is from Advocates for Children. Rebecca, thanks for coming back to the show. It's been a while. We haven't seen you.
Thank you for having me and for your interest in Advocates for Children's work.
Of course. First of all, I just want to ask you how your summer's been.
It's been good. It's been, as we'll be talking about, it's been an incredibly busy summer, but it's been a great summer.
What have you been doing at Advocates for Children? What's been, why don't you give us a little bit of an update of what's been life's been like at the office?
Absolutely. So Advocates for Children is a nonprofit organization that works within New York City to ensure that every student receives the educational opportunity and services that they are entitled to. I'm, as the director of litigation, I focus on a lot of the court work that we do, including class actions and other impact litigation. This summer has been incredibly busy. We have a number of long-standing lawsuits. One of them was filed in 2003. We thought we settled it in 2007 and 2008, and it has been continuing on. And that's why I'm here today to talk to you about that lawsuit.
Yeah, tell us a little bit about it. Just the basics of it to begin with.
Absolutely. So when a parent of a student with a disability disagrees with the supports and services that a school and a school district are providing for their student, the parent can file what's called an impartial hearing or a due process hearing, which in New York City is basically a mini trial. It's before an administrative judge, a hearing officer, who takes evidence. There are opening statements and closing statements and evidence and testimony, and then decides whether the school district, the New York City Department of Education, was actually providing the appropriate services for the student, or whether the student actually needs additional services that the parent can get for that student. Sometimes the orders require the DOE to actually provide the service, to offer a new school, to provide services like speech therapy, physical therapy, occupational therapy, transportation, a nurse. And sometimes it requires the DOE to actually pay for those services. If the DOE didn't provide those services initially, the parent can find a private provider to provide those services, and then the DOE is required to pay. The reason we brought the lawsuit originally in 2003 was that the DOE had no system for implementing these hearing orders and wasn't implementing these hearing orders. So the parent would go through this whole lengthy process, which unfortunately sometimes takes up to a year to go through, would get an order from a hearing officer requiring the DOE to either take some action or pay, and then the DOE wouldn't do it. So we filed this litigation, this class action litigation in 2003. We reached a settlement in 2007 requiring the DOE to implement all orders, all of these hearing orders within 35 days for the most part. And then the DOE didn't do it. And what we started to see in 2018 and 2019 as in fact that the rate that the DOE was implementing these orders within 35 days was going down incredibly quickly, to the point that by 2019, 2020, the DOE was only implementing about 5% of the hearing orders within 35 days, which wasn't acceptable. These are students who have been trying to get these services for years. They're getting harmed by not getting these services. And the DOE was delaying their receipt of these services even longer.
Well, let me ask you a question. Why can't they get this done within the 35 days? Is it tough to get the speech pathologist or whoever it is that's needed? Do they not have the resources? What's the excuse for not getting it done within 35 days?
Unfortunately, the reason was that the system was broken. What happened in 2019 is that we requested that the court appoint what's called a special master, a third party, an independent third party, to go in and look at what was happening within the DOE system for implementing these orders, identify the problems, and then make recommendations. The court appointed the special master after the pandemic in 2021, in May of 2021. And the special master started this process of investigating what was happening within the DOE system for implementing these orders, and found a lot of problems, from the computer system and platform that the DOE was using in order to implement these orders being so antiquated that it was crashing repeated times within a minute, to there not really being any way for a parent to reach out to the DOE when they had questions about the implementation of the order, or the order wasn't being implemented. There was no hotline for the parent to call, to staffing issues. People were not getting trained on how to implement the orders within the DOE. People were leaving. There were no real consistent messages about what was required in order to implement an order, and staff being overwhelmed by all of this.
Where do we stand now?
So the special master issued this first report with his findings in March of 2022. And then issued a series of recommendations in March of 2023. What happened with those recommendations was a court-ordered requirement of more than 40 provisions of steps that the DOE must take in order to change its implementation system, from upgrading its technology and its platform for actually implementing these orders, recruiting new staff, training staff, wonderfully for parents, creating a hotline that parents and providers can call when hearing orders aren't implemented. All of these steps are really going to hopefully allow the process to move forward, to allow parents to get the orders implemented a lot quicker, more quickly. And when they have questions, they're going to be able to find someone who can answer those questions within the DOE a lot more quickly.
Well, that's great. I mean, that's just great news. I mean, it's really, you're holding them accountable and you're making sure they do it now. And hopefully we're not going to be coming back in the next 2 or 3 years because they didn't implement the 41 or 41 steps that they needed to implement. But it's certainly good advocating on behalf of Advocates for Children. And I want to congratulate you. I think that's wonderful.
Thank you very much. And our plan is to hold them accountable. And now the judge is holding them accountable, which is what we want.
And we'd love you to come back and let us know how it's going in the next maybe couple of months, if you could.
Absolutely. Thank you very much.
All right. Stay with us. Today's Verdict has much more right after this. Well, that's all we have for today. I'd like to thank our 3 guests for joining us, and of course, you, the viewers, for watching. If you have any topics or an issue you'd like to see on a future edition of Today's Verdict, feel free to email me at davidlesh@bronxnet.org. Till the next time, know your issues, reach a verdict. I'll see you in 2 weeks.